and permit me to thank you very much for attending this press conference. As you are aware, this is the end-of-year press conference of the Attorney General Chambers and Ministry of Legal Affairs for the year 2023. In this press conference, I intend to give a brief overview of the main tasks which we have achieved as a ministry for the year 2023 and to project with brevity what we plan to achieve in the year 2024. After that overview, I will then invite questions. You are free to ask me questions, obviously, in what I have narrated, but you are also free to go beyond that and ask me any questions you believe may be relevant to my sector. So the Ministry of Legal Affairs and Attorney General Chambers is the principal legal advisor to the government of Guyana and by extension the state of Guyana. We are responsible also for the drafting of legislation across the government and state sector to meet the government's developmental agenda in every regard. Additionally, as principal legal advisor, we are required to offer legal advice and guidance to every ministry of government, to the office of the President, and to all government departments. In addition, we are also engaged in giving advice to the state sectors as well. In our constitutional construct, it is the Ministry of Legal Affairs and the Attorney General Chambers that has responsibility from the executive arm for the justice sector. So it is the Ministry of Legal Affairs and Attorney General Chambers that act as a liaison between the executive and the judiciary in all matters concerning the administration of justice and the rule of law. Of course, the judiciary is an independent constitutional agency, and therefore there are specified parameters which determine how that interaction is to take place. You will know that we have been giving sterling support to the judicial sector of our country in ensuring that they are adequately resourced to provide the quality and type of justice that the people of our country deserve. The mission statement of our ministry is to ensure an adequate system for the administration of justice, to give sound legal advice and provide competent legal representation to the Cooperative Republic of Guyana, and to draft legislation that will give effect to the constitutional, political, and social objectives of the government. In this regard, our policy objectives and priorities include, but are not limited to, review and reform of the existing legal and institutional framework to modernize the legal architecture of the state, liaising with the judiciary to ensure that the judicial arm of the government is sufficiently resourced to discharge its constitutional mandate with efficiency and to ensure access to justice for all, especially the poor and the indigent. Working to establish a regional law school in Guyana under the administration of the Council of Legal Education for the West Indies, establishment of a constitutional reform commission, and assisting in the discharge of its mandate of reforming the Constitution of Guyana based upon wide public consultations. To conduct land regularization exercises in partnership with state agencies such as the Sugar Welfare Fund, the Guyana Lands and Surveys Commission, the Central Housing and Planning and the Ministry of Housing, to regularize squatting settlements across the country and to ensure that certificates of title or transports are provided to persons who have been occupying these lands as squatters for generations. Revising the laws of Guyana at periodic intervals and ensuring due publication of the law reports of Guyana. And significantly, managing and monitoring the Guyana's anti-money laundering, combating the financing of terrorism, AML-CFT structures to ensure compliance with international standards, and continuing to prepare Guyana's legal system to battle organized crimes and AML-CFT types offenses. In terms of local litigation, we are engaged in hundreds of cases against the various arms of the state, including cases which challenge the conduct of members of the Guyana Police Force and indeed every other state agencies, to defend complaints against violations of the Constitution, and importantly, defending institutions of the state and government in respect of political challenges. For example, the elections, petitions, and matters in relation to governance and the government of the state of Guyana. I will not regale you with the number of cases that are pending in the system, but I wish to report that Guyana continues to be a highly litigious society, with cases being filed against the government and the state on a regular basis. Then we have international litigation that are ongoing. You would recall that Smart City Solutions Holding Links have sued the Cooperative Republic of Guyana, and that case is presently pending at the International Center for Settlement of Investment Disputes, ICSID, in Washington, D.C., United States of America. I pause here to detail that this is the case involving the nefarious parking meter deal which was entered into under the last administration. The state of Guyana has been sued for $100 million US, and when we got into government, we were forced to defend these proceedings. Over $2 million US have already been expended in this matter, and it is still ongoing. We are now in the process of presenting our case, our defense that is, to the tribunal and preparing our witnesses who are to testify in support of our defense. These witnesses involve local persons as well as international experts. In particular, these local persons may have to travel to the US and will have to be accommodated. That will cost another lump sum of public funds. Then we are in the process of retaining, based upon our legal advice, experts in the United States of America as well as in Guyana who will bolster our defense. These experts, again, have to be paid with hundreds of thousands of United States dollars. I say that to you so that you and the public will understand the humongous expenditure of public funds that continue to be made for blunders which we inherited from the previous administration. This is monies that could have been spent on all the activities that the opposition party would have gone to old age pension. It could have gone to the increase in public servant wages. It could have gone to our children in the education sector. It could have gone to improve our public health services, and in so many social areas that require huge financial injections. But these monies have to be diverted to address an unnecessary dilemma that the previous government has plunged us in. There is also pending a case between the Rice Development Board and the Agricultural Marketing Institute and the Republic of Panama. You will recall, under the previous administration, large quantities of rice was purchased from our local farmers under the previous administration and sold to Panama, and payments were never received. When we got into government in 2020, we began to explore the payment of this debt. We were forced to institute proceedings in accordance with the supply contract at the International Chamber of Commerce Arbitration Center in Washington, D.C. Again, we were forced to retain lawyers in Washington, D.C., again expending over $150,000 US thus far in legal fees. Fortunately, the Panamanian government, through intervention at the level of His Excellency the President, has agreed to come to the table to discuss an amicable resolution of this matter. But this is after we instituted proceedings at the International Chamber of Commerce. Of course, any compromise of illegal proceedings require both sides giving up something. Based upon the proposals we have received, which we are actively considering, Guyana may have to forego the interest that would have accrued under the debt. The interest is almost the same size or larger than the principal now, having regard to the length of time that the monies took to be paid. The principal sum is approximately 7 million US dollars, and the interest is at almost the same level. Why there is a great temptation to settle, though we may have to write off the interest, is that we will have to expend hundreds of thousands of US dollars at the arbitration proceedings, and win we may. But at the end of the day, we are dealing with a government, and we may have, even after winning, great difficulty in securing payment from a government. An arbitral award, though binding, is difficult to enforce against a government. It's not a private entity whereby you can seize the assets of that entity. Here you are dealing with a government of a country. And it is often very difficult to enforce judgments or arbitral awards against a government. So while we may get judgment at the arbitration proceedings, the judgment may end up being not worth the paper it is written on if we are unable to enforce it and secure payment thereunder. Those are the considerations that are heavily prevailing upon our minds as we negotiate a settlement of this matter. The negotiations are still ongoing and may conclude very shortly, but central to the conclusion will be, while the negotiation is taking place, Guyana being paid whatever sum we agree to, even if it is only the principal sum. That is 7 million US dollars, which are due and owing to the rice farmers of our country, and has been due and owing for over 7 years. Our drafting department continues to be the main vehicle through which legislation, bills, regulations, and subsidiary legislation are being crafted for promulgation in our National Assembly. That process is ongoing, and I will detail for you at a later stage the number of legislation, important ones, that we have passed for the year 2023 and what we have in the pipeline for 2024. We continue in the ministry to be the main engine that is driving Guyana's intention to establish a regional law school in Guyana under the auspices of the Council of Legal Education of the West Indies. We were directed by the Council of Legal Education to prepare a feasibility study to establish the viability of such an institution in Guyana. The ministry, as an extension of the government of Guyana, has assembled a unit that is tasked with the responsibility of piloting this initiative. That unit is working to conclude the feasibility study. We have already secured from the University of Guyana a plot of land on the grounds of the university that will accommodate the intended law school. We have already secured from a company of architects and designers an architectural design of the intended law school, and we are continuing to liaise with the Council of Legal Education to secure from them more information that is required for the preparation of the feasibility study. This initiative will continue during the year 2024. This, as I've indicated elsewhere, is part of the government of Guyana's vision to make Guyana an offshore educational center of the region. The initiative to create, or rather to establish a law school within the geographic space of Guyana is not an isolated one, as it goes hand in hand with government's endeavors to secure offshore universities and training centers here in Guyana in various endeavors and various educational pursuits as well. So it's only part of our government's vision to create an offshore educational center on these shores. I have spoken a lot about law revision. As you know, in the 2023 budget, provisions were made for the revision of the laws of Guyana to update it from 2012 to 2022, December the 31st. Why 2012? Because 2012 was the date that the last revision exercise was completed. So the purple volumes of the laws of Guyana that you now see in force was completed in 2012. The revision exercise, rather, of those laws was completed in 2012. Prior to that, the previous revision exercise was done in 1977. So there was an unfortunate protracted hiatus from 1977 to 2012. So from 2012, we would have passed many pieces of new legislation, and we would have amended several existing legislation. All of those are now part of the revision exercise. The revision exercise is the insertion of the new bills that we have passed, the new legislation, into the existing volumes, as well as to insert the amendments to existing statutory provisions where they are supposed to be. So let us say that we are amending the Criminal Law Offences Act, and we have made an amendment to Section 45. In an amendment, the revision exercise will involve inserting in the principal legislation the new Section 45 that we have inserted, and the renumbering of the legislation so that there is a seamless insertion of the new addition into the existing legislation. That is what simply a revision exercise is. And of course, to insert new bills that we would have passed so that the number of our laws will become larger. This exercise will be completed. It was supposed to be completed in December of 2023. Unfortunately, because of the volume of the work, we were unable to meet that deadline. We have contracted a law revision company that is operating out of Anguilla, the Law Revision Center of the West Indies, and they are conducting the exercise in collaboration with the drafting department of the Attorney General Chambers. This exercise has been, the date for completion has been rescheduled, and it should be completed and launched before the first quarter of 2024. This will involve both soft copies of the law as well as hard copies in different and disparate volumes. You will be invited, of course, to the launching exercise, and you will have a more realistic picture of what I'm speaking about. Our land regularization exercises continue across the country. This year, last year we commenced a land regularization exercise. Well, I don't think it's last year, I think it's the year before. We commenced a land regularization exercise along several villages of the west coast of Berbice. Cotton Tree, number 1, 2, 3, 4, and 5. This year, very early in the new year, we will be distributing a number of titles, over 100 titles, to villages within that proximity, so that over 100 families will now get titles for lands that have been occupying in those villages for over a century. This is by no means an insignificant accomplishment, as it required every single house lot that these people have been living on to be surveyed, streets adjusted. People had to adjust their fences so that we can have proper legal access, then record the information of each occupant / owner of each plot of land, and record in whose name the titles are to be issued, and then going through an entire legal process with the land court judge or the commissioner of title for titles to be issued. It's a very protracted process, and it took a lot of time, but we are now concluding one phase of it that will result in the issuance of approximately 100 titles very shortly in the new year. There's a village called number 46 village in the Quarantine Coast. That is an entire village where the village for nearly 100 years have been, or villagers or residents of that village have been living on private lands in that village and paying rent for those lands. And they have been living there for 100 years. The government has decided to regularize that village, to expend all the resources to ensure that these villagers end up with titles for the land that they are living on. That process is ongoing, and during the course of this year, again, dozens of families will be issued with their titles, compliments of the government. And in all these exercises, the people who will benefit from these titles are not paying for any of these services. We conducted a similar exercise at Bath, West Coast, Berbice, and in January 2023, we distributed 30 titles. In Enterprise on the east coast of Demerara, we did a similar initiative, and we distributed over 75 titles to an entire segment of the village. At Tushan on the west coast of Demerara, we did a similar exercise, and we distributed over 75 titles in that area. That was also widely covered in the press. On the Essequibo coast, we are conducting similar exercises in villages such as Jib and Paradise, and one on the Pomeroon River by the name of, I believe it's Enterprise, I'm not sure. And there is another one on the Essequibo coast that we are working on currently. The name is eluding me right now. I don't have the note here. But these are all ongoing exercises being led by the Attorney General Chambers and Ministry of Legal Affairs as part of the Government of Guyana's initiative. And also, we are working in collaboration with various agencies of state. On the anti-money laundering and countering the financing of terrorism front, you are aware that we are constantly engaged with the Caribbean Financial Action Task Force and the Financial Action Task Force in ensuring that Guyana meets its evolving international obligations in this sector. The evaluation exercise, which is carried out all year round across the Caribbean, involves a mutual assessment of each territory's jurisdiction at periodic intervals to ensure that the jurisdiction meets the international compliance standards. Guyana just completed its 4th round of mutual evaluation on-site examination during the course of 2023, and a preliminary report was sent to us, and we were invited to comment, to add, to subtract, to suggest changes where we feel that that report did not contain a fair assessment of any particular aspect of Guyana's sectors or Guyana's system, and to, if the report has omitted anything, to ensure that it is added. We sent our response to the preliminary report, and we will be reviewed in Trinidad and Tobago during the month of May of this year, 2024. But from all indications, based upon the preliminary reports and based upon what I'm informed of, the last time I engaged the Caribbean Financial Action Task Force, Guyana acquitted itself reasonably well at that assessment. Many countries in the Caribbean have encountered severe difficulties in meeting their respective obligations. Guyana, comparatively, as I said, has done reasonably well. And with the opportunity being given to us to make a further contribution to the preliminary report. Once those contributions are adopted and incorporated into the final report, it will simply and only augment and enhance Guyana's assessment. In terms of the judiciary, as I said, we continue to partner with the judiciary in ensuring that they have the requisite resources necessary to provide swift and available access to justice to all of our people across the length and breadth of our country. In this regard, the government of Guyana continues to invest heavily, both on the capital side, on the recurring side, as well as from a human resource perspective in the judicial sector. For the year 2023, we commissioned a new magistrates court at Vigilance at a cost of $263 million. We turned the sod for the construction of a new magistrates court at Timeri on August 18, 2023, at a cost of nearly $304 million. The sod was turned for the construction of a new magistrate court at Friendship on the east bank of the Amarara, and this new magistrate court is intended to be adjacent to the new highway we are building, alternative to the current East Bank Highway. That magistrates court is expected to cost $388.8 million. The sod was turned for a new magistrate court at Anna Regina on October the 2nd, 2023, $178,232,000 there for that magistrates court. You know that magistrates courts are under construction at Mabaruma and at Port Kaituma and at Madhya as well. So right across the region, right across the country, we have new courthouses that are under construction. The Judicial Service Commission, as you may have observed, was appointed after some delay, and the Judicial Service Commission has commenced the process of recruiting members or persons to the magistracy and to the High Court. Advertisements have been published in the daily newspapers inviting suitably qualified applicants. I have not seen advertisements for Court of Appeal judges. You would recall that we amended the Court of Appeal Act to increase the complement of judges of that court to, I believe, 7 or 9, I can't remember. You will check that, fact check that for me. But so we ought to have advertisements soon published seeking suitably qualified persons to apply for the post of justices of appeal. It is our hope that we can have sufficient number of judges to have 2 Court of Appeal sitting at the same time. We already have expanded the facilities at the Court of Appeal building to accommodate 2 courts. So it is our hope that you can have two appeals being heard by two differently constituted courts, either simultaneously or one after the other. We also hope that we can have sittings of the Court of Appeal in the county of Berbice and in the county of Essequibo, because appeals from the Berbice High Court or the Berbice Full Court and the Essequibo High Court are heard at the Court of Appeal building at Kingston. Once we have a sufficient number of judges, it is hoped that these appeals can be accumulated and judges can be assigned to sit either itinerantly or at longer periodic intervals at these different counties to hear and determine appeals emanating from these counties, obviating the need for the lawyers and litigants to travel all the way to Georgetown to have their appeals heard. It would also remove a lot of backlog pressure from the Court of Appeal in Georgetown. The Ministry of Legal Affairs during the year 2023 has launched a new initiative to bring greater public awareness to our laws. It is our view that unless the law is simplified, it cannot be understood by the ordinary citizen. And unless it is understood, it cannot be properly obeyed by the ordinary citizens. When such a state of affair exists, it is the beginning of a breakdown of law and order in a country. Knowledge is power. If you, the people, do not understand what your legal obligations are, then how will you be able to discharge those obligations? The law is sometimes written in a language that is not easy for the ordinary person to understand. As a result, we have begun an initiative to simplify the law, and we have launched a television program under the title Simplifying the Law, and with the kind compliments of the National Communications Network, we have been able to broadcast a weekly one-hour program edifying the public on different pieces of legislation. We hope that you, the journalist, will use that program and develop new stories therefrom to further enhance and intensify this public awareness program. You, as journalists, are free to participate in the program, either by volunteering to be interviewers or to sit as part of the panel discussion with the legally qualified person so that you can bring a different view. This year, we hope to make the program even more interactive by getting different sectors of the country involved in the program. So we are hoping to bring in the private sector and the various areas in the private sector that the particular legal or the particular legislation may relate to. So if we're discussing a matter of insurance, we bring somebody from the insurance sector. We hope to bring also members or prominent organizations from the social sector. If we are dealing with domestic violence, then we should have someone from an agency whose portfolio responsibilities touch and concern domestic violence. That's the type of engagement and interaction that we would like to see on this engagement. Of course, this program is also being shown on DPI platforms and in the social media. You are free to take excerpts from it and make it part of your news program as well. The Ministry of Legal Affairs and Attorney General Chambers, as instructed by His Excellency the President, was responsible for organizing on behalf of the President the Commission of Inquiry into the Madhya Dorms fire. That exercise was completed and the report will be delivered to the President shortly. As you know, the Attorney General Chambers and Ministry of Legal Affairs, again, is playing a central role in the Guyana-Venezuela border controversy. We are working along with the Office of the President and the Ministry of Foreign Affairs in coordinating Guyana's common position. We have retained lawyers, as you know, and the proceedings are ongoing at the International Court of Justice, and we are working closely with the Office of the President and the Ministry of Foreign Affairs in ongoing engagements with the Bolivarian Republic of Venezuela to ensure that there is a resolution of this matter at the International Court of Justice, but to engage with the Bolivarian Republic of Venezuela to ensure that there is peace and stability on our border fronts and our territorial integrity remains intact as we await the determination of the ICJ proceedings. You would have been aware that I accompanied His Excellency to the engagement in St. Vincent, and I'm pleased to report that that engagement was highly successful. It moved us from a precarious position of danger to a place now where we have relative calm and civility, both at our borders and at the level of the two governments involved. I have seen all manner of opinions expressed in the press, some critical of the way that we handled the issue, but we are convinced that we have acted in the best interest of Guyana, in the best interest of the people of Guyana, and in the best interest of the territorial integrity of Guyana. Those who have the luxury of being not directly involved can, in their usual armchair general style, theorize and pontificate. We are the government. The buck stops with us. And if I have to say so myself, the government of Guyana acquitted itself with distinction so far on this matter at every step of the way. And we will continue to act with the same degree of diligence, competence, and in consultation with our international allies. The Ministry of Legal Affairs continues to administer a program being funded under the Inter-American Development Bank, and the name of that program is the Support for Criminal Justice, is the Support for the Criminal Justice System project. And under that project, we have achieved a number of objectives. I have been speaking about them for the past 3 years. The objectives of this project includes the reduction of inmates who are pretrial detainees and the increase of the use of alternative sentencing in the country. The project has a legislative component and a non-legislative component. The legislative component is manifold, and we have achieved a number of legislative changes. We have done a Bail Act, which has been passed. We have done, we have reviewed the criminal justice, the criminal law, the Summary Offences Act, the Summary Offences Act. We have done a complete review to remove from that law a number of antiquated, archaic offenses. That matter is in the Parliament. That bill will be taken to the Parliament shortly. It is under that legislation, that project, that we have done a new family law bill which will overhaul the Domestic Violence Act, and that is being done under the Ministry of Human Services. We have done sentencing guidelines, which is a work in progress. Only today, I see in the Chronicle a commentator lamenting on the lack of sentencing guidelines in the country. Well, sentencing guidelines are being done by a consultant under this project. It is in draft, and a copy has been sent to the judiciary, whose input is significant, and we have suffered some delay at that juncture. I spoke with the Chief Justice only 2 weeks ago in an effort to accelerate the judiciary's input. I hope that my intervention will bring greater speed to the process, but certainly we are cognizant of the need for sentencing guidelines, and we are working on that. We have completed a bill that will abolish preliminary inquiries, and that bill is in the Parliament. That intervention will bring significant alacrity to the criminal justice system by removing the need for a preliminary inquiry in matters which require preliminary inquiries, such as murder, manslaughter, rape, treason, and those serious offenses. A preliminary inquiry takes an average of about 3 years to complete. If this legislation is implemented, a case can be removed from the magistracy to the High Court within 3 months. Of course, we will now be removing the backlog from the Magistrates' Court over to the High Court, and we are cognizant of that. So we now have to equip the High Court with more judges and more resources. During my last stint as Attorney General, we had increased the complement of High Court judges from 12 to 20. We have less than 12 now. So we are anticipating a large number of appointments that will meet this new demand. Of course, the implementation of the bill will be staggered to ensure that there is enough resources in the judiciary for this to be smoothly implemented. It will require, in essence, that the prosecution serve all their statements on the defense serve all their statements on the prosecution, and when that exchange is completed, both sides go before the magistrate, and they make submissions as to whether a case has been made out for a trial by judge or jury, what is called a prima facie case. So rather than every witness going in the witness box and talking a whole long story, statements are now going to be exchanged by the two parties, and they go before the magistrate, and they address the magistrate on whether there's a prima facie case or not, and a ruling is made there. The DPP will continue to have that power in the event that the DPP feels that a magistrate has erred, to go to a high court to challenge the magistrate's error. The accused person also has that right. Those are facilities that are going to be retained in the new promulgation. We will also be amending the law to allow for judge-alone trial. Right through, and let me go back to the paper committal bill. The paper committal bill is already with us in the Sexual Offences Act, because that's an act that allows for paper committal. So it's not a new thing, and in any event, it is something that is already implemented across the Caribbean, and the Caribbean Court of Justice, when they were in this very room and in this very building, they called for the implementation of the paper committal legislation in Guyana. We are also, as I said, implementing changes to our law that will allow for judge-alone trial. There are certain cases where it has now been accepted that the interest of justice is not served or not best served, where judges must sit with a jury. And we in Guyana will now embrace that reality. There are certain technical cases that is unfit for consideration by the jury. And that's an internationally accepted phenomenon. England has moved in this direction decades ago, and so has many countries in the Caribbean. We are moving in that direction now. The law will tell you where the choice lies. Is it the judge that must determine whether a case should be tried before a jury? Should it be the director of public prosecutions, or should it be the accused persons? We have to look at what the trend is across the region and follow that trend. Under that project as well, we have unfolded the restorative justice program. I have spoken a lot about the restorative justice program, but in the year 2024, this program will kick off in a real way. Upon an examination of all the circumstances in the country, having regard to our existing structure, the nature of the restorative justice project itself, the nature of how it is to be unfolded, the amount of resources that are available for the implementation of the program, I have made the conscious and considered decision that I will ally that project with the probation department of the Ministry of Human Services. The probation department of the Ministry of Human Services offer a service that is akin and analogous to the restorative justice concept. It interacts with the judicial system right across the country in the same way or in a similar way that the restorative justice system is intended to operate. And most importantly, it has physical infrastructures across the region, in particular at strategic locations where our judicial and magisterial centers are. So because of the commonality of the concepts, I believe that a marrying of the two initiatives will serve the public well, and both services, once integrated, will be able to be delivered in a more coherent and efficient manner across the length and breadth of our country in service to our people. And it doesn't require a complete new unfolding of buildings and facilities across the country to accommodate restorative justice officers. They will be accommodated, as I said, in the edifices of the Ministry of Human Services, Probation Department, and will function alongside those agencies, or that agency. You know, we have launched a new program, which is a new initiative, never tried anywhere in the Commonwealth, and that is to specially train our graduates from the Bachelor of Laws degree program at the University of Guyana and make them special prosecutors after an intense period of training. That period of training was in essence collapsing the 2-year syllabus that they would have been required to undergo at one of the regional law schools and expose them to that compressed syllabus and then put them in the magistrate's court to prosecute. We have graduated over 50 such persons, more than 50, 60-something such persons, who are currently functioning in the magistrate's courts in most of the regions in our country. That is a successful pilot, and it will enhance the prosecutorial capacity of the state. I have a whole list of bills that have been passed in 2023. Another set of bills that are in the pipeline. Another set of bills that are in the ministries, most of which I am hoping to pass in 2024. I would not bore you by reading out the entire list. You can get a copy of it to get in a nutshell what is our legislative agenda. Significantly also, and I will conclude on this point and open for questioning. I think that I have bored you enough. The Attorney General Chambers and Ministry of Legal Affairs, again under the direction of His Excellency the President and the Office of the President, worked towards the establishment of a commission of inquiry that inquired into the irregularities and misconduct in relation to the March 2nd, 2020 elections. That again was another successful initiative, and a report was produced and widely disseminated. And that report found that there was grave misconduct on the part of political actors, but more importantly, on the part of key functionaries of the Guyana Elections Commission. This is a significant matter that every Guyanese should be interested in. Free and fair elections in any country is the foundation of a democracy. A democracy is a foundation of a lawful society. A lawful society is the foundation of a progressive, developing, orderly society. They are all interrelated. It means that if you don't have free and fair elections, at the other end of the spectrum, you're going to have chaos, you're going to have a breakdown of law and order, you're going to have economic stagnation, you're going to have social degradation. And we have lived through that as a people. We had 28 years of rigged elections in this country. It resulted in 28 years of economic stagnation, social degradation, social instability, and financial bankruptcy. They all go hand in hand. And when you have independent constitutional agencies such as GCOM, that the Constitution has assigned the responsibility of ensuring free, fair, independent, and democratic elections, and the people, through their taxation dollars, spend billions in ensuring that these objectives are achieved. And then those who are responsible for delivering on these imperatives are found undermining the system, perverting the system, and corrupting the system in order to deliver a result different from the mandate expressed by the people in the ballot boxes, then we have a serious problem. And that is what the Commission of Inquiry was appointed to inquire into. And it made some fundamental findings in this regard. And that brings me to some 30-odd charges that are pending in the magistrates' court of our country, involving some of the very players who misconducted themselves and abused their powers during that electoral process. After 3 years, those charges have not been able to secure a trial date. Well, let me put it this way. The trial of those charges have not yet begun. Now, I am the Minister of Justice. I cannot be pleased with this state of affairs. No decent-minded Guyanese can be pleased with this state of affairs. And I wish to make it abundantly clear that these are not politically driven or inspired charges. These are charges that relate to misconduct of the electoral process by persons who have been appointed and paid by the taxpayers of this country to manage and man that process, to ensure that the process meets the imperatives of transparency, legality, and fairness. Nothing to do with politics. These are the most serious offenses pending in our court system. And all of you are observing what is transpiring. And like me, I have no doubt that you are of the impression that the matter is not being treated with the seriousness that it deserves. These are matters of national importance, of international significance. 100 governments across the globe came out and condemned the conduct that they witnessed. And here it is, charges have been filed. And after 3 years in our court system, the trial in relation to those charges have not yet commenced. And it behoves me to comment fairly but critically on the reasons why. Magistrates after magistrates have found reasons that can't withstand scrutiny for not proceeding to try these cases and other related cases. Magistrates have found reasons after reasons to recuse themselves. The law of recusal is clear. Some of the reasons are somebody is a member of a credit union, with one person, or somebody serving the army with the husband of one of the defense counsel. These are some of the reasons that have been given in some of these cases and in other types of cases as a basis for a recusal. I am aware that the Director of Public Prosecutions has written to the Chancellor of the Judiciary requesting the Chancellor's intervention. The Chancellor has a supervisory authority over magistrates in the country. Now, let me just give you a comparative example. Under the previous administration, you know that I was charged. You know that Dr. Ashley Singh was charged. You magistrate recused themselves. Not one magistrate recused themselves. And the magistrate before whom I was tried could have recused herself because I got her the job that she got at the Director of Public Prosecution's office. That never came out in the trial. That was not a basis to recuse. Unless you speak about these things, nobody knows. And in the year 2024, we are going to be more open and more frank on these matters. There is no sacred cow in the state of Guyana. All of those who are paid with public funds must be subjected to scrutiny, respectful scrutiny. I am not attributing any ulterior motives to anyone. I am simply relating the facts as I know them. So I'll pause there and I'll invite your questions. Thank you very much for your patience.
Hi, good morning. This is Anil Nandlall. A couple of questions from me to start off. I want to follow up on the last thing you just spoke about. We're virtually a year away from the next general and regional elections. I know you mentioned that the engagement with the Chancellor, but how do you actually see this going forward now? And do you expect that the matter will be resolved before the next general and regional elections?
First of all, it is a travesty that an entire electoral cycle is going to be completed, or it is in its fourth year, and a new cycle is going to start, and these charges are still pending.
Well, what exactly, I'm trying to understand, what exactly should come out of the engagement with the Chancellor? And do you believe
I think the request is to assign magistrates specifically to deal only with these cases until they are concluded.
My other question is, you spoke about Smart City Solutions Park, the meter deal. I wanted to understand, is settlement at all on the table, or is that completely off of the table for the government?
The claim against Guyana is $100 million for services that was rejected by the people of Guyana, for services that was never enjoyed by the people of Guyana. The project never got off the ground. And from the public outrage expressed at the time, it would appear as though the people of Guyana are not ready for that type of facility, at least in the form in which it was presented, and at the cost that it would have attracted. So what are we paying for? What are you going to, 100 million US dollars, what are you settling at? If you settle at quarter of that sum, it is a humongous sum of money to pay for nothing.
My final question, now you spoke about the Mohabir report, the COI, the report of the COI. Are there any preliminary findings that you can share, or is the report not?
No. I can't share any preliminary finding. The report has not yet been delivered to the president. So I don't have access to the report.
When you said,
So that's a matter completely for the president.
you said shortly, when can we expect it?
Before the end of this month, certainly. Before the end of this month.
Jarrell Bryan, Guyana Times. Question on the statement. You spoke extensively about the local law school, but I want to know specifically the Council of Legal Education. Has there been any word on final approval, or is this conditional on the feasibility study?
The approval for the law school has essentially been given preliminarily. But we have to satisfy certain criteria and participate in a process before that decision is crystallized. And that is the process that we are participating in. I believe the council has reached the position that there are going to be additional law schools and that one will be located in Guyana. So, but we have to go through a process.
Okay, and two other questions, not on the statement. Can you provide an update on Troy Resources and efforts to recoup monies that were owed to the state, whether it's crossed into arbitration? And also, I know it's not strictly under your ministry, but has the AG Chambers been engaged on possible arbitration with the Exxon money, the US $214 million?
I know that the Ministry of Natural Resources is engaging Troy Resources on amicably resolving the differences. It has not reached the Ministry of Legal Affairs as yet. In terms of the Exxon matter, no, that has not reached the AG Chambers as yet.
Good morning.
I'm hearing you.
My mic is on, that's why you're not getting through. I have a follow-up question on the law school approval. The answer you gave today is relatively close to what you said last year when we did an
Sorry, I
interview.
didn't hear you.
The answer you gave today is relatively close to
The
what we've
the
been
what?
hearing. In regarding to the law school,
Uh-huh.
the answer you give is relatively close to what we've heard since last year about waiting for satisfying the criteria. What are some of those criteria the government has to satisfy in order for this to roll off?
I agree with you that there has been a holdup, and that delay is largely attributable to the fact that we have not gotten from the Council of Legal Education's law schools information that we have requested and that are required to do the feasibility study. Only last week, I dispatched a letter to the chairperson of the Council of Legal Education informing her that we have requested this information, we need this information, and unfortunately, the information has not been supplied from the sources, by the sources to which we have requested them, from which we have requested them. And I requested her intervention as chairperson. So I agree with you that there has been, my expectation was that by the end of December, we would have completed the feasibility exercise. It is very much near completion, except that we need the statistical data from those law schools. We need data like, for example, how many students they have accepted over the years, how many applications they have received and not admitted, to get an idea of how many students are floating around the Caribbean who are qualified to go to a law school but have not been offered a space at the 3 existing law schools. Things like that that we need, that are crucial to the feasibility study, is what we have not been getting from them.
Another question, you have spoken about amendment to laws. I'm wondering if the cybercrime are one of those.
A very good question. I have indicated before that the cybercrime legislation will be reviewed. You will recall that when it was enacted in 2018, we were in the opposition. We, including yours truly, spoke emphatically against certain provisions, and we withheld our support from it. The United Nations is working on a new cybercrime convention, out of which will come a model legislation. Guyana is playing a significant role in the crafting of these 2 instruments. Our Deputy Parliamentary Counsel, Ms. Joanne Bond, and Attorney at Law Trishala Prasad, who's working in the Guyana High Commission not the Guyana High Commission, she's working with the UN Guyana office in New York, are leading Guyana's efforts. In fact, Guyana is leading the Caribbean efforts because it's a model bill for different parts of the world being done by the UN, and they are doing one specifically for the Caribbean. And we are leading on that initiative. Ms. Prasad and Ms. Bond have traveled to several conferences and meetings, both in the United States of America, to the United States of America, as well as various other places in Europe where these meetings have been held. They ought to be concluding those instruments for the year 2024. As soon as those instruments are completed, we are going to implement the model legislation with adjustments that we may make to make it even more suitable to the Guyana experience.
Briefly, can you say what some of those adjustments might look like?
No, the existing law will be repealed. That's the first thing. Completely repealed. And the model law is the one that we will use as our guide. Any model law that you get from any international agency, more likely than not, you have to adjust it to meet your local circumstance. The adjustments are going to be slight, small. They are not going to alter the substance, but will simply make the type of adjustments to make it compliant with Guyana's local realities.
Good morning, Mr. Nandlall, Antonio de Starbuck News. I just have a question relating to a Facebook post that you would have issued. You said the Natural Resource Fund Act overrides tax obligations of Exxon and partners as enshrined in the 2016 Production Sharing Agreement, which is the PSA. I wanted to know, is this the government's position, and does it mean that the sanctity of the PSA does not exist?
A government position got to coincide with the law. What I have expressed there is my view of the law.
Okay.
I am the government's principal legal advisor. The sanctity of contract must be respected. I have said nothing in that post or in those two exchanges which I have had that ought to lend to any inference that I do not respect or appreciate the sanctity of contracts. What I was trying to convey in that article is that at the time when the contract was entered into, there was no existing framework to govern oil revenue. The contract sought to make certain provisions. Now, the contract has certain provisions in it that prevents certain type of legislation from being passed as well. I know that, the stability clause. I don't write without those type of ideas informing what I write. None of those restrictions touch and concern the government's capability to create an infrastructure and a regulatory framework into which will be put oil revenue. In fact, as a manifesto promise, and go to our manifesto, you will see 2 or 3 pages dedicated to the establishment of a sovereign fund in the manner, sovereign wealth fund, in the manner that we have outlined in that legislation. You will recall that APNU AFC filed legal proceedings challenging that legislation. One of the grounds upon which they challenged the legislation was that the People's Progressive Party government did not consult when we enacted that legislation. And according to them, consultation is an integral part of lawmaking. Now, in my view, that is a notion that is completely wrong. There is nothing wrong legally with implementing a law without consultation. It may not be politically advisable to do so, depending upon the nature and purport of the law. Countries pass law every day without consultation. So that argument, I reject. However, I also put to the court that there was widespread consultation, that the People's Progressive Party in opposition for 5 years walked this country and spoke about the establishment of a sovereign wealth fund. For the preparation of our manifesto to go to the elections, we held several specific consultative exercises for the preparation of the manifesto. And we discussed the sovereign wealth fund. And we spoke about it at hundreds of political meetings and rallies during the election campaign. where we spoke about the Sovereign Wealth Fund and the accompanying structure around it. And I was able to submit to the court our manifesto and highlight the pages of the manifesto where we spoke of the Sovereign Wealth Fund and that we will create it by legislation and what the other tenets of the legislation will contain. I was able to almost use express language from the manifesto pages to put in my submissions to say, look, this NRF Act was not hatched up. It is in the manifesto in the exact framework and manner that is now present in the Act. So there is no, come back to your original question, there is no conflict between what I said and sanctity of contracts. Every day we enter into contracts. Right now I am reviewing several multi-million US dollar contracts with the government, that the government of Guyana will be entering into. Every day, that's part of my responsibility. And once you enter into those contracts, you are bound by the contractual terms. If you violate them, you stand to face the consequences of those breaches. All right?
Okay, sir.
Thank you.
I have two more questions, if you permit me. In March last year, the government released its 5-year national strategy to combat money laundering and the financing terrorism. Can you say what progress has been made in boosting capabilities of the Financial Intelligence Unit? There have been a number of charges, which I know you're cognizant of, obtained and convictions concerning what we call gold smuggling, right? Which has seen one of the biggest laundering threats here. Can you advise the progress the government has made in that regard?
So thank you very much for that question. It allows me to elaborate something that I had to speak on, but I skipped it. So, as I outlined in my overview, we continue to work under the supervision of the Caribbean Financial Action Task Force, our regulatory body in this region, on all AML-CFT matters. That involves updating our laws at periodic intervals, modernizing our framework, enhancing our capabilities, and engaging in training exercises to do so. We have partnered with the Regional Security System, RSS Asset Recovery Unit, and we have held a number of workshops in Guyana during the year 2023. These workshops and training sessions have been attended by all the important players in our National Task Force on AML-CFT. They include the judiciary, the magistracy, the DPP, the police force, the Guyana Police Force, including SOCU, CANU, the Guyana Revenue Authority, the Guyana Geology and Mines Commission, the Guyana Gold Board, the Guyana Gaming Authority, and some other, the Bank of Guyana, and even members of the private sector. We have done many of those. The last one we held was at Juke Lodge from October the 9th to the 13th. You may have attended the launch of that. Then we worked with that very agency in updating our laws to enhance our capabilities to do civil forfeiture. They did a model legislation on civil forfeiture. And when I speak about civil forfeiture, I mean civil forfeiture of properties that are considered to be proceeds of crime or acquired by proceeds of crime. Traditionally in Guyana and in many parts of the Caribbean, we have only been going after the perpetrators and not the assets acquired. We now have to shift focus. And we did comprehensive review to our legislation to ensure that we now have the legal capabilities to go after properties of the criminals and properties acquired or believed to be acquired from criminal activities. So you will see people's expensive properties now being implicated in legal proceedings as we begin to unfold our civil forfeiture agenda. That is one of the weaknesses that have been identified to us in our recent assessment. The assessment was done in August, I think, or September, and I had passed the law only in August. So the law was not yet fully enforced or not yet fully implemented at the time when the assessment was done. But we were able to show to the assessors that, look, we may be late, but we have the law now. And going forward, we will now be going after assets of criminals and assets that are connected to criminal conduct. We have also partnered with the OA, Organization of American States, in training programs to help us improve our capabilities to detect, to investigate, detect, and convict in the area of illicit and illegal mining. Again, we had a massive workshop during the last week of November, going on to the first week of December, at Cara Lodge. We were a team from the OAS and the US Embassy, collaborated with Guyana's National AML-CFT Task Force, and we had a protracted engagement. So our training and our continued preparation in this sector is a work in progress, and we will continue in that regard.
Okay, and my last question. The Public Procurement Commission has said that it does not have the legislative framework to subpoena and examine witnesses. Do you agree that the government is planning, or in any chance are they contemplating to improve the powers of the Public Procurement Commission?
The Public Procurement Commission Act is now over 2 decades old, and would be undergoing a review shortly during the course of this year. So that we can further enshrine accountability and transparency, but most importantly, to ensure that contractors deliver their projects on time, that they deliver the quality of work contemplated by the contract, and there is a regime of penalties that will be imposed when there is breach of those obligations. There will also be a mechanism that will allow for a fair and transparent system of blacklisting of contractors who are guilty of repeated breaches of contract. And delinquency in the discharge of their contractual duties.
Quick question on that last point you made about blacklisting. I know you were speaking specifically to contractors with public contracts and so on, but there have been a lot of people complaining about contractors, private people, and contractors not doing their duties and so on, robbing people and so on.
Well, look, as far as I'm aware, the law, first of all, we can only speak about the government sector. But private citizens or citizens who are engaging in contractual arrangements have to ensure that those with whom they are contracting discharge their contractual duties in the manner and form contemplated and agreed upon. There is an adequate system of laws out there that would provide reasonably adequate redress, for persons who are aggrieved by contractual conduct in their private transactions. I always say to persons, because every day people come to me for advice, because they still feel that I can advise on these matters and I ought not to, but people still come to you for advice, and so you try to help as much as you can. Guyanese, they do multi-million-dollar businesses, and they are not educated or trained in the law, and the business has a large legal component, and they do not seek legal advice. When you don't do that, you are bound to find yourselves in problems. People must understand that if your car breaks down, you call a mechanic. If you're not feeling well, you go to see a doctor. If you want to build a house, you seek a contractor. If you're going to engage in a legal transaction, then you need to seek a lawyer's advice. But everybody wants to be a lawyer in the country. And that's causing half of the problems. Many cases I'm seeing. Multi-million-dollar transactions, and persons are entering into them without seeking legal guidance. You don't understand what you're agreeing to. You don't understand the ramifications of what you're agreeing to. So when there is a problem, they go to the lawyers. Sometimes it's too late because they have signed an agreement. That is sometimes bad. So you go to the doctor after the patient dies, or when the illness is too advanced for the doctor to make a preemptive and constructive engagement and intervention.
But is there a possibility of a blacklist for these private
No, government can blacklist private people. That's not government's business.
Or a registry or something?
No country has that system. The law, the legal system doesn't allow you. Government can't get itself inserted in people's private arrangements. That's not an undertaking that government will ever want to engage in.
All right, and a question, what's the latest update on the review of the Local Content Act? And
I have not engaged with the local secretariat for a while. In my last engagement with them, and this was what we agreed to from the beginning, that after a 2 years being in force, or such similar period, we will collate all the deficiencies, inadequacies that we would have uncovered as you begin to operate the law. And once that accumulation is done, then we will conduct the review. And that was my last engagement with them. So they are collating that, and hopefully they bring it to me sometime during the course of this year, and we can begin to work on that.
okay, and can you speak to your chamber's efforts to build capacity for oil and gas? I know last year you set up the arbitration unit and so on. How's
So-
that gone so far?
Lawyers have to do a lot of reading. We have purchased a lot of books in the area of oil and gas, and we are reading. In my view, the greatest endeavor in learning the law is one that is self-generated. It's your own desire to know the law, to learn the law, and to learn as much as possible of the law. I personally don't believe that going to a university presents one with a greater platform. That's my personal view. However, we have put into the gold program a number of scholarships relating to oil and gas. Only a few days ago, again, I spoke with the Gold Scholarship people, and I have asked them to insert 10 scholarships for postgraduate studies in arbitration. A lot of it will have to do with oil and gas arbitration. The arbitration bill, as you know, is in the Parliament. This year, I will unfold another set of training initiatives with international agencies, both in the Caribbean and in North America, in relation to arbitration. We are already planning one for the first quarter of this year. I have already engaged the Department of Law of the University of Guyana and have commenced discussions with them to teach arbitration as a core subject at the LLB degree program level. Arbitration is going to be a big thing in Guyana going forward. We have the most modern arbitration law in the form of the bill in the entire Caribbean. But we are different because our bill is perhaps the only bill in the region that allows for an arbitration center located anywhere to come and establish a presence in Guyana, either permanently or transiently. So that the biggest arbitration organizations that are in North America and Europe and Asia can come to Guyana under our law and set up shop. So you don't have to go to Japan or Tokyo or Switzerland and New York and Washington and Paris to do arbitration anymore. You can do it right in Guyana. The people can come. That's why the private sector now got to start to build out proper facilities for arbitrations to be done in Guyana. All of that, we have to promote that bill. But what the bill does is that it embraces the gold standards for arbitration across the globe. Once anyone who is au fait with arbitral proceedings, they look at our bill, they will see that it meets the international standards. So they ought not to have any difficulty in coming to Guyana to do arbitration. Arbitration involves billions and billions of dollars sometimes. It's a great industry. It will bring people to this country. It will cost money to be spent in the country. It will provide employment. It will help the hotel sector. It has multiple spin-off benefits. And we're keeping all of that right here in Guyana rather than allow it to be done somewhere else. You know the oil spill of the Gulf of Mexico? You saw movies and so on about it, Mark Wahlberg. The arbitration proceedings was done right here in Nassau, Bahamas. It involved billions and billions of dollars paid in compensation. And it was done right in Bahamas. If it can be done in the Bahamas, why it can't be done here? We are putting in a law that is even more modern than the Bahamian law. So that's the type of vision that we have for the arbitration sector in the country.
AG, Samuel Suknan in the NCN News. Has the government examined ways to strengthen the laws to address investment fraud? I'm speaking in the context of the Ponzi scheme. You know, it's not prevalent now, but it was back in 2020, 2021.
We are modernizing the financial and legal sector from every possible perspective. It was not a lack of law that allowed that Ponzi scheme to be perpetrated and grow to the extent that it has grown. It was the gullibility of people to believe that you can put in $100,000 into the scheme and by weekend get $300,000. I mean, I say with the greatest of respect, you have to be stupid. And some people I know put $100 million in it, $160 million. I'm a lawyer. I deal with businessmen. I used to, when I was in private practice, I know people who don't, they are embarrassed. Because if this information goes out, it affects their credibility. And people still asking me on Facebook, what is the government doing about the Ponzi scheme? What can the government do about the Ponzi scheme? We were not in government. And then as soon as we got in the government, we dismantled the scheme. Rather than thank us, they are blaming me and blaming the government. What are we doing? Who tell you, you come to us? Did you come to the leader of the opposition office? Did you come to Anil Nandlall and ask him advice? Somebody you never meet in your life, you giving him millions of your dollars, and he tell you give him back 10 million this weekend. So laws can't protect persons against stupid decisions. You can have the best laws in the world. If you make decisions that are irrational, you can't blame the law for that.
Just a quick follow-up question. Last year you mentioned that you were going to move to get the money owed to you by the opposition after your unsuccessful cases. Has there been any progress on that?
They have substantially paid off the sums of money that they had owed as costs. Because I wrote them and I told them that I'm going to garnish their salary from the parliament. So I don't think they wanted me to do that. You know, there's a provision in the law that if you owe, your creditor can go to your employer and get a court order directing the employer to pay you the salary instead of the employee. So I was planning to write the parliament as they pay their salary to me rather than them. But I think they pulled up their socks very quickly and they made most of the payments. As I am speaking, we have not received any notice of appeal in respect of the last petition that was the appeal in relation to the petition that was dismissed by the Court of Appeal last month. So they may have finally come to the realistic conclusion that engaging in further litigation in relation to those elections only constitutes wasting the court's time, their time, and our time. They should have listened to me since 2020. I told them that. 3 years after, they have proven me right.
Hi, AG. Celestine One, Guyana Chronicle. I know you spoke about the election COI, right? And its finding. However, the COI have recommended that campaign financing laws be in place. Can we see this enforced before the next elections?
In our manifesto, that is one of the promises that we have made. So Thursday, you can raise it at another forum.